Yep. Okay. Go!
Will you hand me my screen box?
Now go.
This is the Sandra Bowd and Stanley Stock matter, file 22-10637-CZ. Counsel, you want to place your appearances on the record. Plaintiffs first.
Thomas Levin on behalf of the plaintiff.
David Svengros on behalf of the defendant.
All right, this is a motion to strike defendant's amended witness and exhibit list. Go ahead and argue it.
Your Honor, we had a scheduling order back in October indicating that the witness and exhibit lists were to be filed and exchanged 30 days before trial date. And that would have been trial dates January 7th, and approximately 30 days before that would have been December 7th, December 8th. Plaintiffs filed their witness list about December 8th. Defendants did not file a witness list at that time. And we had a pretrial conference on December 23rd, where defendants counsel indicated that he had served the witness list on December 2nd. That turned out to be false. In effect, the witness list eventually was not actually served until about December 29th, 2025. We've gone through this before. We continually get these challenges from the defendant in terms of even the scheduling order, how many days the court allowed in terms of each particular aspect of the scheduling order. We get the defendant's attorney saying that the lists here were served on December 2nd. They weren't. I asked him when he sent me he sent me a preliminary list just on a regular piece of paper indicating that there were two witnesses, and that was like around this, I would say December 29th and about there. I said, I want to see the proof of mailing, and I want to see the actual list. And when he finally sent it to me, it turned out that he hadn't sent out a witness list on the 2nd. And in effect, the first time I see an amended witness list is last week, December 29th. And I think it's unfair. We've had problems before in getting answers to interrogatories. I had to bring a motion to compel, to have deposition, a motion to compel. Everything here is obstructed and basically made hard. And we have to bring motions all the time in order to get the defendant's cooperation. There's a prejudice here. I should have been informed of who the witnesses are more than 5 days before trial. And for the defendant's attorney to look at the court and say he sent it out December 2nd is totally false. And I think there should be a sanction here. Whether I ask for striking the list, but even if the list is not struck, I think then there should be some monetary sanction, $600, to say that this is not the way this matter should be litigated. And that's my motion, Your Honor.
Who is on the defense's witness list that you want struck off?
Mrs. Stock, Wendy Stock struck off. And apparently there's another, I don't have it in front of me because I had a rush to get in here this morning. I'm sorry
Shelley
about
Schmidt?
that. Sally Schmidt, yeah.
So basically you want him limited to his client, Mr. Stock.
That's correct.
Mr. Svengros?
Well, thank you, Your Honor. I have a couple of things I want to say. First, I want to apologize to the court. I did sign a witness list on December 2nd, but for some reason it didn't go out. In regards to allegations about somehow we've impeded on discovery. It's simply not true. The reason that there was a motion to compel the deposition of Mr. Stock was because Mr. Levin didn't take Mr. Stock's deposition within the discovery period. In regards to prejudice with these witnesses, all of these witnesses were listed in the initial disclosures. I haven't added to any of them. He never conducted any discovery of these witnesses, no interrogatories, no depositions. He did take Stanley Stock's deposition. If we look at this case, there's only three issues. What are the amounts that Mr. Stock claimed as compensation? What were the amounts of the trust when it started? What were the amounts at the end? And what is it based on? Stanley Stock's deposition has already been taken. If he doesn't want Mr. Stock to appear, he won't. If he doesn't want Mrs. Stock, she's going to be there if the judge wants to hear. If you want to hear from her, you can hear from her. In regards to Shelley Schmidt, I told Mr. Levin specifically that I wasn't calling her. So this is the stuff that we've been dealing with in the beginning, and it's not coming from my end. It's, you asked us to be civil to each other. I replied to his emails and told him I wasn't calling Ms. Schmidt. He's not prejudiced. Why it would cost him $600 is beyond me. Every once in a while, you can get a case that makes you wonder why you practice law. And this is it. 3 years of this. He's had 3 years to take these people's deposition. There's no issues in this case. One way or another, it's got to be done tomorrow. And I'm done with it. And I'm done with him. And, Judge, you can do whatever you want, as you know. But there's no prejudice to Mr. Levin. But this is an example of what I've been dealing with for 3 years. Okay. I have nothing further.
Thank you. Mr. Svengros, was Wendy Stock and Shelley Schmidt on a list that was provided to the court within 30 days of tomorrow?
No.
Then they won't be allowed to be witnesses at the hearing tomorrow because that was the court's order.
And I wasn't going to call them anyway. They were here for.
And I get that. Okay. So let me reiterate to both of you. I am a minimalist. I don't want to hear when I ask a question about witnesses, about past depositions. I don't want to hear it. I'm not going to listen to it. I let you in your argument today do it because that's where Mr. Levin went. Mr. Svengros answered it, but it just takes us off topic. I get it that the two of you are having difficulties getting along with each other. That happens. We're big boys. Deal with it. I am, however, not going to listen to it tomorrow. I will not sit here for 3 hours and go over something that we could have done in an hour and a half. So tighten up your arguments. Let's get to the specific issues and do nothing but the specific issues tomorrow, because you will not like me if you go where you have gone in the past. If we get off topic and we get in the weeds and we start saying what the other side did or didn't do, I don't care. I have absolutely no desire to do the history of this case. You have an issue that comes before me. That's the only thing that I want to hear about tomorrow. If you start talking about what the other attorney did, I'll sanction you from the bench. So I'm not going to listen to it. Have I made myself clear?
Yes, Your Honor.
Yes.
Your Honor,
Thank you.
I've got an emergency situation. I thought I'd bring it up now.
Go ahead.
My car, my automobile is in the shop. They tell me it'll be ready today. I'm not positive about it. And I plan on driving up to Gaylord tomorrow. And I don't know what to do in that situation. That is the automobile I use, and I hope it gets done today, but I don't know, and I don't know what I can do. I don't know if I guess I'm thinking, could there be an adjournment of a week, or could we go by Zoom? I'd have to, I'd have to email the exhibits to you.
Every time that I've tried to do a contested hearing via Zoom, it's been an unmitigated disaster.
I completely agree.
So the answer to your question is rent a car.
Yeah, again, in keeping with, despite the fact that there may be nobody who wants this case to end quicker than me, if Mr. Levin is requesting an adjournment, I will do that, but it's got to be more than a week because my next week is absolutely filled.
It's not going to be a week because the court doesn't have time a week in advance. We schedule 3 months out. So I might be able to find you an hour or two in a month, but we're not, I don't have, tomorrow I have a whole day. That's my trial day.
I understand.
And my trial dates fill up very quickly. And I still don't believe that we're going to be able to get the two of you through a hearing, even if we only have 2 witnesses in anything less than half a day. To find another half day is going to be months, most likely down the road. So Mr. Svengros and Mr. Levin, is that what you want to do? You want to adjourn tomorrow and bump it months down the road?
I think that's fine from my end. I don't want to get in a situation where Mr. Levin is unable to make it. I don't want to do it by Zoom. From my end of it, a trial, I don't have any witnesses. The only one I have is Stanley Stock. Other than that, there's no argument there. The legal arguments are in the briefs. And, you know, I tried to end this with a motion for summary disposition earlier for the judge to decide it one way or the other. But anyway, that's fine with me. If Mr. Levin can't make it, I'm not going to jam him on something or the court and have us all be there and him unable to get there.
Mr. Levin, are you asking for an adjournment?
Yes, I am, Your Honor.
All right. Tomorrow's hearing will be off. The court will work on my schedule. I can't give it to you right now because that's going to take 2 or 3 people to do some magic. So tomorrow's hearing is off. We'll send you notice of the next court date available. Mr. Levin, do you believe we can do anything less than half a day?
I'll need Mr. Stock's testimony may basically take a half a day or at least a third of a day. And my client it won't testify to very much except as what she rebuts to what Mr. Stock has to say. But so probably going to need at least a half a day to be safe. And I don't think we'll go much more than that, but maybe part of an afternoon or something to that effect. Not much, I don't think. And I don't know what Mrs. Fengros is going to have his, Mr. Stock testify to, but I would think it wouldn't be much more than a half a day.
The only concession I would ask, Your Honor, is this would certainly give Mr. Levin time to depose Mrs. Stock. So he should take that opportunity.
Well,
right.
As far as I know, Mrs. Stock is no longer going to be a witness.
That's the cooperation I was looking for. Well, it's fine, Your Honor.
I'll send a notice to both of you. Thank you very much. That's all for today.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. Today is an absolute joke. You need an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir. Put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in first. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. But trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.